Hi, this is Malik again, and today what I'd like to talk about are motions to reopen with the immigration courts. Every so often, or more often than not, someone is ordered deported or removed from the United States by an immigration judge. And they may not like that decision, so one thing they can do is appeal it. Or sometimes they fail to appeal in a timely manner, which is normally 30 days, and therefore they have to do what's called a motion to reopen. A motion to reopen generally has to be filed within 90 days of the order of removal, or 180 days if the person failed to show to court for the immigration hearing. In that case, someone does not come to the court and the immigration judge determines that the person was properly notified, and they determine that the DHS, Department of Homeland Security, has established that the person is removable or deportable, and orders the person in his or her absence, removed from the United States. So there's 90 days, 180 if it's an in absentia order, or it can be at a later time if there's proof that there was not notice. Besides the no notice, 90 days or 180 days in absentia, motions to reopen can also be filed quite some time later. And oftentimes this is the case. We at the law offices here, we have handled a large number of motions to reopen, sometimes many years after the original removal or deportation order was issued. And we have to look for a way to determine if the case can be reopened. Was there an error? Was there a fault? Or possibly, is there now new relief, meaning a new way to obtain residency or immigration status? Is there now relief that was not previously available? And if that's the case, we meet with the client, we discuss the case, and we will then begin to prepare a motion to reopen, which is a somewhat daunting, challenging, and burdensome task. But if done well and correctly, there's a good chance of success. For those of you out there that have been ordered removed or deported, and why I use the word removed or deported will be a discussion in another video blog, but those of you who have been ordered removed or deported, what you need to do is understand that you do have an outstanding order of removal, and this may put you in jeopardy at any instant if you happen to cross paths with immigration and they do detain you and seek to execute that removal order, that is, deport you from the United States, physically deport you. If you're in this situation, you need to be prepared. One of the hardest things here at the office is someone comes in a panic state because someone's been detained because they have an outstanding removal order, something happened that triggered ICE's attention to them, and now quickly we need to file a motion to reopen. Now, obviously we'll do our best, but it's difficult in a pressured situation when the person is detained and the family members may have limited information to share with us about the situation that led to a previous deportation. So, if you've got an outstanding removal order, what you need to do is be prepared for the event that something may happen, or you may have a reason, new relief, to reopen the matter. You may want to obtain copies of your entire file from your previous attorneys, or those who helped you. You may want to file what's called a Freedom of Information Act request, and you can use the assistance of an attorney to help you with this. But you want to do this that you may have just a packet of documented information that you can present to me or another competent attorney in order for when and if that moment arises that you have to file a motion to reopen, your attorney and you aren't blindsided. We've got all the facts that are necessary to file this motion to reopen, and then we can prepare a comprehensive packet with evidence, submissions attached to it, and really urge the judge to reopen your matter. And oftentimes, if we can get a matter reopened, then the chances of the person being able to stay, or at least being able to get bond and release from immigration custody, are enhanced dramatically.